The Real Estate Settlement Procedures Act, or RESPA, protects home buyers by requiring lenders to disclose terms of the real estate settlement process. A real estate agent who violates this act can face severe penalties. This makes RESPA a crucial part of the real estate exam, so students must understand it. Hello everybody, it's Zach here from realestatelicensewizard.com. Today we're talking about the Real Estate Settlement Procedures Act. Let's get started. So what is the Real Estate Settlement Procedures Act? Well, RESPA requires that lenders and mortgage brokers provide home buyers with disclosures regarding the real estate settlement process. This act, also known as Regulation X, protects home buyers from predatory lending agreements. Now, before we understand how RESPA works, we must understand what a settlement service is. A real estate settlement service helps home buyers with the closing process after purchasing a home. These organizations generally provide title insurance or offer escrow services. So why was RESPA passed? Before RESPA, there were a few laws regulating these types of services, but nothing substantial. This meant that lenders could get away with abusive behaviors, including doling out predatory lending terms. That's why RESPA was passed in 1974 to protect borrowers from these practices and support a fair housing market. Now, there are two components of RESPA. One, to provide borrowers with timely mortgage disclosures, and two, to prevent predatory lending practices. Under RESPA, homebuyers must be made fully aware of mortgage loan terms before entering into the settlement. RESPA also provides that lending companies cannot engage in illegal lending practices. Now, under RESPA, borrowers must submit the following loan terms to be considered for a mortgage loan. These are the 6 pieces of information for RESPA: name, income, social security number, property address, an estimate of the property's value, and loan amount. So how does RESPA protect home buyers? Well, RESPA protects home buyers from unjust practices and surprise fees and mortgage loans. Under RESPA, lenders have to be upfront about the costs of their real estate settlement services. They must disclose a good faith estimate of how much the borrower will pay. This allows consumers to make informed decisions and shop for the best deal. RESPA also prohibits mortgage and real estate companies from adding kickbacks and referral fees to the cost of a real estate settlement service. This saves homebuyers money by ensuring they only have to pay for the cost of the actual work being done. Finally, RESPA allows homebuyers to seek help if a mortgage company overcharges or takes advantage of them. If a lender includes hidden fees in a home loan, home buyers are protected under federal law and will not have to pay these charges. So what loans does RESPA cover? Well, the Real Estate Settlement Procedure Act covers all federally related mortgage loans for 1 to 4 family properties. And I will put a list on the screen of what these loans include. So home loans, home improvement loans, refinances, equity lines of credit, reverse mortgages, and even lender-approved assumptions. Now, there are loans that RESPA does not cover, and I'll put those on the screen as well. So extensions of credit to the government, loans for businesses, loans for commercial purposes, and obviously loans for agricultural purposes. So let's do some examples of predatory lending tactics that force home buyers to pay more that were prohibited by RESPA. So 1, offering kickbacks and referral fees. 2, requiring large escrow account balances. 3, inflating cost of services. 4, bribing in exchange for referrals. 5, not disclosing good faith estimated settlement costs. And then 6, demanding title insurance. So who enforces this law? Well, it's the Consumer Financial Protection Bureau. It's important to note that home buyers obviously must bring up the claim no matter than 1 year after a violation or potential violation has occurred. Otherwise, the CFPD will be powerless to seek retribution for the borrower. So what are the penalties for violating RESPA? Well, it's going to depend on the severity. For example, creditors and real estate brokers who accidentally violated RESPA may have to pay only like $100. However, more serious offenses can result into fines of like $10,000 or even a year in prison. In private settlements, violators may even be fined an amount equal to 3 times as much as the charge paid for the service. So how do parties avoid violating RESPA? Well, for lenders, they need to ensure that they properly disclose the terms of all real estate settlement procedures. They should avoid sneaking in hidden fees or offering gifts to agents in exchange for referrals. Real estate agents must also be careful to avoid violating this act. The best way to follow RESPA is to never accept fees, kickbacks, or other items of value from real estate settlement services. While referral fees are legal in some states, their use is not exactly recommended as it can lead to severe legal risks. A real estate agent can still help their clients by cross-promoting other businesses, but they shouldn't financially benefit from doing so. Now, there are some problems with RESPA. Some critics say that RESPA fails to eliminate all predatory lending practices, and it might not even be strong enough. For example, lenders can still legally provide captive insurance to the title companies they work with. Many argue this is an example of a kickback, as it incentivizes real estate agents to work with specific businesses. RESPA is supposed to prohibit this behavior, but currently there's really nothing in place to regulate this particular practice. Ultimately, critics of RESPA call for amendments that will ban this loophole and end kickbacks in real estate once and for all. Now, obviously, RESPA was amended. Since 1974, many amendments have been made to improve and empower the law. In 1990, there was something called the National Affordable Housing Act, which required that lenders provide disclosures regarding the sale, assignment, or transfer of mortgage servicing. This allowed homebuyers to clearly understand the mortgage loan terms before agreeing to the settlement. There was also an amendment in 1992. This one essentially made sure that RESPA would cover subordinate lien loans. A subordinate lien loan or a subprime mortgage is a loan against a property with a low priority status. Previous to 1992, subprime mortgages were actually not covered under RESPA. And then there was 1996, where there was the Economic Growth and Regulatory Paperwork Reduction Act, which this just clarified specific definitions and reducing mortgage services provision disclosures. This helped streamline RESPA and the real estate settlement process for mortgage companies and borrowers. There was also a 2008 RESPA reform rule that occurred. This amendment required that mortgage companies provide good faith estimate form to give borrowers an idea of settlement costs. It also removed outdated provisions and simplified the real estate settlement process. Then, of course, there was the 2010 Dodd-Frank Wall Street Reform and Consumer Protection Act, which I believe I have talked about a few times on this channel. But these laws essentially empowered the Consumer Financial Protection Bureau to actually enforce RESPA. So under this amendment, lenders and real estate agents who would violate the law would be actually investigated. And then there were a couple more amendments in 2013 and 2014, and essentially those just added provisions for escrow payments, force-placed insurance, general servicing, and loss mitigation. And you know what, guys? I assume that there's going to be even more amendments because this is such a fast-moving industry, which is another reason why you need to be informed. So what do you need to know for the real estate exam? Well, the Real Estate Settlement Procedures Act requires lenders to disclose the costs of the real estate settlement procedure process for federally related mortgage loans. This act is essential for lenders and real estate agents to follow and understand. Now, you do not need to be aware of all those amendments that we went over. You do need to understand the context of RESPA and how it's evolved throughout the years, and obviously what its current form is. So that's why I kind of explained that. You also need to be aware of kickbacks and its relationship to RESPA, because obviously that relates to real estate professionals today. So be aware of those things and you'll be good to go come exam day. For more videos on fair housing, fair lending, and all that good stuff, click here and click here to subscribe. Thank you guys so much for watching. Until next time, see ya. Bye-bye.